Hello, everyone. My name is Lee Cunningham. I'm NACADA's web event producer, and it is my pleasure to welcome you to today's webinar, It's on Us Too, Understanding and Navigating Title IX as an Academic Advisor. We'll begin by having each of our presenters introduce themselves. Shannon, would you begin for us, please? And don't forget to unmute.
See, first technical glitch of the day.
There you go.
My name is Shannon Lynn Burton, and I am the Associate University Ombudsperson at Michigan State University.
And Mark?
Hi, everyone. It's an honor to be here. I'm Mark Duslack, and I'm the Director of Student Development at Lake Sumter State College.
Great. Thank you both for being with us today. And Shannon is going to get us started, so I will pass the mic along to her now. Shannon?
Thanks, Lee. Welcome to our presentation on Title IX for academic advisors. I served as an academic advisor for many years, and in my current role as Associate University Ombudsperson, work with both complainants and respondents in the Title IX reporting and investigation process to help them better understand the process itself and their rights within it, especially as it may relate to their current academic standing within the institution. As a result, I felt it important for academic advisors to better understand what we mean by Title IX as it relates to relationship violence and sexual assault and their role in supporting students as they move through these processes. Mark and I hope to cover a variety of areas to support you in your work. We will discuss why Title IX applies to relationship violence and sexual assault, what the investigations look like, an advisor's role in reporting, the connection between reporting and confidentiality, as well as how advisors can support students, whether complainant or respondent, as they move through the process. For each one of these pieces, I could talk for an entire hour as they are complex and each has multiple layers. Additionally, it is important to note that even the most robust of systems cannot always account for every possibility. That said, we hope that this webinar gives you insight into what your role is and how best to support students. Although today we'll be focusing on Title IX under United States law, I do think it is important to note for those outside of the United States context that similar processes and procedures may be in place for managing similar concerns under other legal and administrative systems. As we talk today, the role of the advisor in understanding reporting procedures and supporting students is universal. Whether you are in the United States or another country, understanding legal concepts as they apply to the advising role is paramount to a successful advising program. So just what is Title IX? When Title IX is referenced, it is really referencing Title IX of the Educational Amendments of 1972. This is a federal civil rights law that prohibits discrimination on the basis of sex in federally funded education programs and activities. On April 4th of 2011, the Office for Civil Rights, often referred to as OCR, in the Department of Education issued a Dear Colleague letter on student-on-student sexual harassment and sexual violence. This letter explains the school's responsibility to respond promptly and effectively to sexual violence against students in accordance with the requirements of Title IX. Among the pieces it explains are the following: guidance on schools' responsibility to investigate and address sexual violence, guidance about Title IX requirements and how they relate to sexual violence, proactive efforts schools can take to prevent sexual violence, connections between Title IX, FERPA, and the Clery Act, examples of remedies and enforcement strategies. This letter supplements the Office of Civil Rights 2001 revised sexual harassment guidance, which discusses requirements as it relates to school employees or third parties. These are the three major pieces of policy that govern how schools might handle cases of relationship violence and sexual assault. For our international colleagues, your institution may have similar policies that govern how you should react to a report of sexual violence. These may not be federally mandated as in the United States. However, again, it is important for an academic advisor to have some knowledge of the processes as well as whom to contact if questions exist. Many of you are probably thinking, how do we get to investigating sexual assault from ensuring equity in athletics? Well, it has taken a few decades for us to reach this place in regards to Title IX, and many would say it's about time. At its outset, Title IX was a means by which equity was to be found for both men and women in athletics. It has definitely increased athletic and professional opportunities for women. However, at its core, it has a simple mandate. There should be no discrimination on the basis of sex. The movement to expand Title IX began in the 1980s as advocates for victims of sexual assault and harassment began speaking up about the issue on college campuses. This was also the era when Jean Cleary was raped and murdered at Lehigh University. Her parents' efforts eventually led to the 1991 Cleary Campus Crimes Act, which I will discuss in a moment. These movements then pushed colleges and universities to take preventative steps. However, issues still existed as these cases were often not prosecuted. Eventually, complainants in these cases began to sue their educational institutions for a lack of action. This was indeed allowable under Title IX since 1979, when the Supreme Court recognized a private right of action in a dispute involving the University of Chicago. Then, 7 years later, in 1986, the Supreme Court held that sex discrimination encompassed sexual harassment. This construct allowed Title IX's non-discrimination language to be applied to sexual assault and sexual violence. However, it did not come to full development until 1987 with Congress's Civil Rights Restoration Act, which expanded Title IX's scope. Finally, in 1998, the Supreme Court held schools were liable for private damages if they knew of harassment under the concept deliberate indifference. This arose from Davis versus Monroe County's Board of Education, where the court felt that the school failed to respond to known acts of severe student-on-student harassment, thereby creating an environment that denies the victim equal access to education, thus taking us to the current Title IX requirements. These policies and requirements are also connected to other laws and acts as required by federal regulations. The first of these is FERPA, which most advisors in the United States receive training on each year. In the United States, FERPA is the Family Educational Rights and Privacy Act of 1974. FERPA is a federal law that protects the privacy of student records. The law applies to all schools that receive funds under an applicable program of the U.S. Department of Education. This is similar to FIPPA in Ontario and other privacy acts in other countries. These policies govern who can have what information and when about a student's educational record. The second is the Cleary Act, which I alluded to previously. Institutions that receive federal student financial aid are subject to Cleary. The Cleary Act requires institutions of higher education to provide current as well as prospective students and employees, the public, and the Department of Education with crime statistics and information about campus crime prevention programs and policies. As Title IX involves the reporting of sexual violence, schools are held to report these incidents under the Cleary Act. It is the intersection of all of these pieces that often make Title IX a confusing and difficult process to manage for many institutions, and why procedures and processes seem to adapt quickly, especially when we look at how an educational right to know is translated in these difficult cases and balancing that with the public's right to information related to their safety. What is covered when we reference sexual violence? The Office of Civil Rights requires that the conduct be evaluated from the alleged victim's perspective. So when violence is said to occur, it can be defined as physical or sexual acts perpetrated against a person's will or where a person is incapable of consent. It can include rape, sexual assault, sexual battery, sexual abuse, or sexual coercion. Some institutions may further define it under their policy for broader concerns to relationship violence. This can include ongoing emotional, psychological, and physical abuse. It can either be a single act of violence or a pattern of violent acts. Often when analyzing these cases, other factors are considered. These include any power differential between the parties. Is it a professor and a student involved in the situation, a student and a student? Existence of fear by either party, tied to specific behaviors that can determine abuse. And finally, the context of the behavior. Are there coercive or controlling tactics involved? Was it an act of self-defense? Under these definitions, when does an institution violate Title IX? Essentially, students must not be denied or limited in their ability to participate in or benefit from programs or activities on the basis of sex. Thus, it is violated when the alleged conduct is serious enough to limit or deny ability to participate, or when the school fails to take prompt and effective steps to end sexual violence, eliminate a hostile environment, prevent its recurrence, and remedy its effects. As I think sharing cases can be a difficult thing to do when we have a wide variety of institutions represented on this webinar today, I offer as an example a scene from the movie Legally Blonde. It is one of my favorite movies for a wide array of reasons, and I often use it in the legal issue classes that I teach. While it is a fictional example, when we discuss hostile environments and a student's ability to complete or succeed, I often think of the scene where Elle's law professor, Callahan, places his hand on her leg under the guise of mentorship. This clearly creates a hostile work environment for Elle, and she decides to quit law school at that point. As the Dear Colleague letter came out 10 years after the movie, I often think about what the process may have looked like for both the professor and the student had the Title IX guidance been in place then as it is today. In my mind, for that situation, it limited Elle's ability to participate in her internship, and the school clearly did not take prompt and effective steps to eliminate the hostile environment. I think this is a great example of a student who could have been a verified complainant under current policies. So far, I have used the terms complainant and respondent. In many of our minds, I believe we automatically go to the use of the words victim and perpetrator. At this juncture, I think it is important to note that one is still innocent until proven guilty, or in this case, responsible. When we work with these cases, unless one deals with them on a consistent basis, it may be easy to get locked into using terms that already define the outcome of the situation or investigation. As a university representative, especially if both students are in your academic program, remaining neutral can really help all parties involved. While one may want to support the alleged victim, also known as the complainant, there also needs to be a presumption of innocence when working with the alleged perpetrator, also known as a respondent. I would encourage advisors to think in the complainant-respondent mindset when working with students involved in these delicate situations. Essentially, a complainant is defined as an individual who is eligible to file a complaint to report a violation of this policy. It also includes any person who is reported to have experienced a violation of this policy in cases where some other person has made a report on that person's behalf. A respondent is defined as the person against whom a complaint or allegation is reported. And a respondent is found responsible when the evidentiary standard meets the level appropriate to the situation at hand. This is only one piece of why it is vital for academic advisors to understand this process. Taking our Legally Blonde example a step further, what would you have done had Elle come into your office and reported her professor or internship supervisor's behavior? After all, as academic advisors, we build relationships with our students that often result in them feeling we are a safe place to discuss life events. Additionally, academic advisors often act as a bridge or a translator between the expectations in the classroom and the student's experience. Thus, maintaining positive relationships with colleagues helps our students. This is where that neutrality is important, even in an advisor's role. Finally, it is imperative for academic advisors to read and be knowledgeable of their institution's policies around these concerns, whether it be federally mandated or not. If you are an academic advisor in the United States, be aware of who the Title IX coordinator is and where the institution's policies are published. Currently, for many institutions, these policies are under scrutiny from those inside and outside the institution, as well as being revised to better reflect processes regularly. So knowing where the resources are will assist you in better working with students who find themselves in this space. If you advise outside of the United States, you should be aware of who the general counsel might be, ombuds, or other university official well-versed in university policy and law, as these processes can often be confusing for both student and advisor. Given all of these processes and the role of the academic advisor, when is it considered that a university knows in the United States? The Office of Civil Rights states that a school has received notice when a responsible employee knew or in the exercise of reasonable care should have known. A responsible employee includes any employee who has the authority to take action to redress sexual violence, who has been given the duty of reporting incidents of sexual violence or any other misconduct by students to the Title IX coordinator or appropriate school designee, or whom a student could reasonably believe has the authority or duty. Again, as academic advisors, we build a level of trust with students who may self-reveal in a variety of ways that an incident has occurred. These notifications can be direct or indirect. Direct notification can be that the alleged victim or complainant has filed a grievance or informed a responsible employee directly. This could happen in an academic advising appointment when one asks a student why they seem to be struggling in a given term. It could even be a paper a student writes for a student success course where they talk about the incident and a reflection of a struggle they have overcome or something with which they are currently struggling. Indirect notification can be someone from the local community or even a social networking site. Many advisors are connected to their students via social media, and given that many students often overshare on social media, it could be that one becomes aware of an incident via this avenue as well. So when an institution has been informed, or in this case, an academic advisor has learned of an incident, they are required to take immediate and appropriate steps to investigate or otherwise determine what occurred. The school is then required to protect the complainant and ensure their safety as necessary, including taking interim steps before the final outcome of the investigation. It should be noted that a school is obligated to also process incidents that happen off campus to determine whether it occurred in the context of an education program or activity. This could include an internship, as in the Legally Blonde example, a study abroad experience, or even a service learning endeavor. All things that as advisors we discuss with students in detail already. I know you're sitting there wondering, how do I know if a student will contact me about an incident of relationship violence or sexual misconduct? What is the likelihood that this will actually happen? In a report from the Association of American Universities in 2016 from their Sexual Assault Campus Survey, they highlighted that some studies have identified factors associated with contacting helping or supportive resources and services. There are 5: who the victim is, the type of incident, the context of the incident, who the offender is, and the consequence for the victim. In relation to the complainant, it is really an indicator of how fearful they are. If they are afraid they may be killed or of additional injury, they are more likely to report. Additionally, when looking at the consequence for the complainant, if there are injuries or if they are suffering from post-traumatic stress, they may be more likely to report. The severity of the incident as well as the context of the incident can also affect their likelihood to report. Was there a weapon present? Was the complainant drinking prior to the event? Each of these pieces, as well as others, can feed into whether or not they will report. Finally, who the offender is plays a role. Is it a stranger, someone they are in a relationship with? The distance of the alleged offender or respondent can increase the likelihood of the report as well. If a complainant does report to you, what should you report? A responsible employee must report all relevant details. This includes name or names of the alleged perpetrator, the student who experienced the alleged sexual violence, other students involved in the alleged sexual violence, relevant facts including date, time, and location. As academic advisors, we may struggle with reporting obligations, especially if we feel a student has come with the expectation that we will be confidential. Mark will be addressing how one works with students directly, both complainant and respondent, in his section. As I am speaking to policy, I will address OCR's perspective on the issue. First off, the Office of Civil Rights strongly supports a student's interest in confidentiality. Additionally, schools are required to maintain information in a secure manner. Information should only be disclosed regarding alleged incidents to individuals responsible for handling the response. There are some students who do not wish to have their name provided to the alleged perpetrator, and in these cases, the complainant should be informed that this limits the ability to respond. There are times where the school must override the student's request in order to meet Title IX obligations, but these are typically limited. If they do not wish to seek action, the school should determine whether or not it can honor that request dependent upon the impact to other students and the overall environment at the institution. There are offices on campus that are offices of non-report that students can turn to for assistance. These can include a counseling center, a sexual assault program, and at some institutions, an ombudsperson based on their standards of practice. For instance, our office is confidential, but are considered private communications under Michigan State University's policy. This means that each year we report the number of relationship violence cases we have discussed, but not the details. Thus, we are an office of non-report. Remember that students, whether complainant or respondent, should receive support throughout the investigation process, and an academic advisor may be someone that they turn to. As students involved in investigations may come to you for support as their advisor, it is vital that you understand the different components of the investigation process. In all cases, the investigation must be adequate, reliable, impartial, and prompt, as well as include the opportunity for both parties to present witnesses and other evidence. Be aware that the impact of an investigation may affect not only the complainant and respondent, but potential witnesses as well. For all involved, this can be very emotionally charged and psychologically stressful. A balance needs to be struck in the investigation. The parties must have an equal opportunity to present relevant witnesses and other evidence. If one party is allowed to have an attorney or advisor, the other is too. If one party is allowed to have expert testimony, the other is too. If a school provides for an appeal, both parties should have equal access to do so. The school's investigation should also coordinate with any other ongoing school or criminal investigations of the incident and establish appropriate fact-finding roles for each investigator. As an academic advisor, it is important to note that these students may not just be affected by the university or college process, but the criminal process as well. If there are other conduct issues involved in the incident, they may also be going through those processes simultaneously. I think it is also important for you to have a basic understanding of the evidentiary standards currently in place for this process, as it is a bit different than what many are used to hearing. You may be familiar with the term beyond a reasonable doubt. Beyond a reasonable doubt refers to the highest standard of proof that must be met in any trial. However, this is for criminal litigation. For civil litigation, as our campus processes are, there are other standards that we consider. The first is clear and convincing. Clear and convincing means that the evidence presented by a party during the investigation is more highly probable to be true than not, and one has a firm belief or conviction in it. However, for Title IX investigations, the standard is preponderance of the evidence. Preponderance of the evidence means that the greater weight of the evidence for the trier of fact to decide in favor of one side or the other. It is based on the more convincing evidence and its probable truth or accuracy, and not on the amount of evidence. Thus, one clearly knowledgeable witness may provide a preponderance of evidence over a dozen witnesses with hazy testimony. Each institution creates their own process for investigations. Thus, what it looks like at Michigan State University may not be what it looks like at Lake Sumter State College. However, all of these processes include interim steps and remedies to protect the complainant and sometimes the campus community. There has been some discussion as to what will happen with the new administration and the requirements for Title IX. From my perspective, and this is only my opinion, even if there is some reversal in the federal regulations around Title IX, I do not foresee universities changing their evidentiary standard. Interim steps and remedies can, and often do, affect the ability of a student to succeed at their institution, whether complainant or respondent. Common interim steps and remedies could include removing the respondent or alleged offender from classes shared with the complainant, having the complainant retake the course that they share with the respondent at no financial or academic penalty to themselves, although delaying graduation may be an issue, and suspension or dismissal from the institution for the respondent, and as well as other remedies. As an academic advisor, one could see how these interim steps, along with the impact of the alleged assault or the impact of the allegation itself, might impact the student's ability to succeed in a normal fashion. However, regardless of the interim measure or remedy, advisor support is key. To further discuss an advisor's role in the process, I will turn the webinar over to Mark.
Thank you, Shannon. So now that we understand Title IX reporting and the rules governing the requirements to report about incidents, we'll move on to discuss the impacts this has on the advising relationship with the student. Namely, we're going to focus on 5 aspects of confidentiality as they apply to reporting Title IX concerns. First, we will discuss the tensions surrounding creating an atmosphere of trust versus following the requirements of the law. This will include a discussion of the 3 levels of protected speech. Next, we'll explore 3 scenarios to help understand the nuances of reporting requirements. From there, we will discuss how to break confidentiality by taking cues from the counseling profession. And lastly, I will provide some suggestions for practice and training. This statement from the United States Department of Education's Office of Civil Liberties outlines the conditions and subsequent actions that are mandated by Title IX. This is the directive Shannon mentioned in her slide about schools knowing about an incident of sexual violence and the necessity to act. It states, when a school knows or reasonably should know of possible sexual violence, it must take immediate and appropriate steps to investigate or otherwise determine what occurred. OCR deems a school to have notice of student-on-student sexual violence if a responsible employee knew or in the exercise of reasonable care should have known about the sexual violence. The 2 important words in this statement are must and immediate. As Shannon stated, once it is known that sexual violence has occurred, action is mandatory. Take note that there are no stated duration limits for investigation between when the incident occurred and when it was reported. In contrast, once the incident is known, the timeline of action becomes immediate. It is uncommon for someone to speak about a topic like a sexual assault directly. Rather, the student may make allusions or indirect references to an incident. Remember, as Shannon illustrated, the standard for reporting is drawn at the point of know or reasonably should know. Before an advising session crosses the threshold of know or reasonably should know, options can be presented to the student. With an understanding of the guidelines for reporting, it's additionally important to understand the tension between protecting individual privacy and campus safety. This statement illustrates the tension inherent in mandated reporting. It states, if the student continues to ask that his or her name not be revealed, the school should take all reasonable steps to investigate and respond to the complaint consistent with the student's request, as long as doing so does not prevent the school from responding effectively to the harassment and preventing harassment of other students. As Shannon mentioned earlier, the student's privacy should be respected when possible. However, this must be weighed against the general safety of others. Again, how much a student discloses during an advising appointment is a key factor in whether an advisor must take actions or whether the advisor has the flexibility to avail the student of campus resources that are offices of non-report. Before going any further, it's important for us to understand a few distinctions about the protections of communications. So let's explore some of the different levels of protection with regard to identity and information. We'll start with privacy, and privacy is a basic entitlement that is commonly granted to everyone. Advisors typically practice a more rigorous level of protection called confidentiality. Following FERPA guidelines is an example of this. Lastly, privilege is the highest form of protection and often includes protection from legal mandates of disclosure. It is very important to note that conversations with advisors are not considered privileged conversations. Therefore, there are no legal protections of the conversation between an advisor and a student. Put another way, if the law requires an advisor to disclose information, they must do so. However, on many college campuses, there are individuals who possess the ability to have privileged conversations. Shannon mentioned these offices of non-report, which include counseling centers and sexual assault programs. These offices of non-report will vary by institution. So now let's expand on all this with a case example. We'll reference scenario 1 from the handout. And it states, you are an academic advisor and a male student enters your office and is visibly distraught. The student alludes to an incident but keeps referencing that he wishes to keep it confidential. So our first question would be, as the conversation stands, does the advisor have a legal obligation to report this interaction? Subsequently, what are the next steps the advisor should take? In my opinion, The student has not disclosed enough information to warrant a mandate to report the conversation. There is no clear indication that a Title IX violation occurred. There is nothing to indicate thus far that there is a threat on campus. To use the language of Title IX, the advisor does not know or should have known of an incident. However, this conversation has the possibility of turning this way, depending upon the details the student discloses further. Knowing what we know now about conversational privilege, it may be in the best interest of the student to refer the student to an office of non-report. Although, this must also be weighed against the context of the conversation and whether it appears that a continued danger remains on campus. Thus, we arrive at the ethical dilemma of meeting the confidentiality requests of the student while maintaining the safety of the campus. Because the student has made the effort to reach out to someone on campus, I suspect we can all agree that some further action should be taken, whether it is a referral or a continued conversation. In scenario 2, we'll add some more details. Again, you are an academic advisor and a student enters your office and is visibly distraught. The student describes an incident wherein she was walking back home at night and was sexually assaulted on campus grounds. She knows the attacker, but refuses to name this person and is requesting that you keep it confidential. In this instance, the advisor clearly knows that sexual violence has occurred. The advisor does not have a choice to end the conversation by suggesting the student speak to someone else in order to maintain confidentiality. Rather, the onus is now on the advisor to report this incident. Even if the student objects to further investigation, the advisor is legally bound to report the incident for investigation. However, the advisor's hands are not completely tied. The way in which the advisor takes the next steps will likely influence the overall result of the experience for the advisee. Remember, the threshold to report is simply the knowledge that the incident occurred. Regarding options for the student, the reporting is mandatory. However, it would be recommended to avail the student of other campus victim services and counseling resources. Let's move on to explore our third scenario, which involves the written word. It states an SLS instructor provides you with an essay written by a male student which references a sexual assault that he experienced while he was a high school student. The report does not name names and is generally vague. In a meeting with you, the student confirms that the essay is a legitimate account of being forced to perform sexual acts against his will by another individual. The student does not wish to discuss the essay further with you and requests that you keep it confidential. You do not know if the respondent is still in contact with the student. Even though this incident took place in the past and the student is expressing a desire to keep the incident private, advisors are mandated to report this incident. Remember, there is no time limit from when an incident occurred to when it can be reported and investigated. The Office of Civil Liberties punctuates this by addressing off-campus sexual violence. It states, once a school is on notice of off-campus sexual violence against a student, it must assess whether there are any continuing effects on campus or in an off-campus education program or activity that are creating or contributing to a hostile environment, and, if so, address that hostile environment in the same manner in which it would address a hostile environment created by on-campus misconduct. Thus, an advisor is mandated to report this incident for investigation. That does not mean that any action beyond the reporting of the incident will take place. That said, there still exists a possibility that a continuing threat could exist. Therefore, reporting and investigation are warranted. Given the occasionally stringent nature of mandated reporting laws, there are likely to be instances wherein an advisor is required to make a report, yet the student is expressing a wish for the information to be kept confidential. The following section will explore ways to break confidentiality. And we'll start off with an example phrase that you can use if you must break confidentiality. It states, as a member of this institution, I am considered a mandated reporter. You shared something with me that must be reported to the proper authorities. I will do my best to respect your privacy, but I cannot guarantee confidentiality. I'm here to help you in this process and would like to talk with you about some of the other services offered on campus. Before going any further, did you have any questions for me? Now, this may sound a little bit dry to some, so feel free to amend the statement to suit your conversational preferences. Let's explore this process of breaking confidentiality a little further. As we have demonstrated, there are instances where the advisor must report an incident regardless of the student's wishes. There is an art to the ensuing conversation once it is determined that a report must be made. First and foremost, the prevailing wisdom is to proceed with honesty and sensitivity. Once an advisor realizes that a report must be made, it can become awkward for an unpracticed or unseasoned professional. So avoid beating around the bush or trying to soften the message. A direct and clear explanation works best. Thus, when needing to break confidentiality, we recommend that the advisor inform the student of the process and describe the sequence of how the process of reporting the incident will unfold. It is important to use language that is sensitive to the student's concern, but maintains your position as a mandated reporter. Explaining why you need to break confidentiality can help a student understand your obligations. Now, even with the best phrasing and tact, advisors should anticipate a negative reaction from the student. There's a reasonable possibility that the student did not wish for their situation to be shared with a larger audience. So feelings of betrayal, fear, embarrassment, or regret may emerge. In these cases, the best course of action is to listen to the student's concerns, appreciate their feelings, and offer a referral to further assistance. For the advisor, there may emerge a desire to tell the student that everything's going to be okay or that the reporting won't be a big deal. In truth, however, an advisor cannot make these promises, so avoid making promises that can't be guaranteed. Rather, it's acceptable for an advisor to promise to do everything in their power to respect the student's wishes within the boundaries of the law. Another important facet of ensuring that the reporting process is as easy as possible for the student is to know the steps in the process. My experience has been that students have more confidence in your suggestions for actions if you have a thorough understanding of the steps and can articulate them without hesitation or question. It is unlikely that you will be making these reports often, so practicing these scenarios is especially helpful. Know who to contact, know the steps, explain the possible outcomes. Get to know the person on your campus who handles Title IX requests. Ask them about how they have handled incidents in the past and gain a summary level understanding of what happens after you make a report to their office. All this will help the student feel that you are competent and further increases the likelihood that you will be able to maintain a working relationship with the student after the report has been made. Additionally, advisors should practice answering the following questions which are likely to surface in the course of making a report. These are just a few questions taken from an FAQ created by the University of Illinois. As mentioned before, it's recommended to know these answers before a student asks them. There may be an occasion where the student you are meeting with is the respondent in an investigation. As Shannon recommended, an advisor's best approach is to remain impartial and provide the student with campus resources that can provide support. This includes legal services, counseling services, the Title IX office, and some campuses even have respondent services. Bear in mind that what the student reports to you is not protected speech. Therefore, it is prudent to alert the student early in the conversation that you cannot maintain confidentiality. So our presentation has taken us through the history of Title IX and outlined the investigation process along with reporting guidelines. We explored how confidentiality and mandated reporting occasionally are in tension. We hope this presentation provided you with greater clarity regarding the levels of protected speech and the instances wherein confidentiality can be maintained or needs to be broken. From there, we provided training and practice suggestions that we hope you will take with you and apply beyond our presentation. This topic can be difficult to discuss, and the nuances of each situation are unique. When a student discloses extremely intimate information, it is an advisor's duty to provide that student with the highest level of professional assistance. Therefore, understanding Title IX reporting guidelines and practicing how to handle a variety of situations prepares advisors to meet the sensitive needs of students in vulnerable situations. We thank you for listening to our presentation today. And what questions do you have for us?
Well, thank you, Shannon and Mark, for sharing all that great information. with us. Okay, so we now are at the question and answer portion of our webinar. So participants, as I mentioned before we began, we invite you to use that Q&A pod and send in your questions so that we can begin looking at what you would like to talk about a little bit further. Also, don't forget, we do have the Twitter conversation taking place on social media, so you're welcome to use that hashtag NACADAweb to take part in that. So let's see, our first question that we have on board is, what further recommendations do you have for professional development activities regarding mandated reporting? So Mark, would you start us off on that one?
Sure thing. Thanks, Lee. Really, my recommendation is any type of development that is going to closely approximate an actual instance of a student making a report that would need to be reported to the Title IX office. So what I would recommend would be something like a role play or a case study. Basically, if you can get as close to the feeling of how you would feel in the moment when you realize that a student is making a disclosure of this nature, I think the better. And I think it's one of those things that it's important to continually practice this because it is something that probably won't come up frequently, but when it does, it's very important to be ready for it.
Okay, great. Shannon, anything to add to that?
Certainly. In addition, I would say a lot of our institutions are requiring individuals to go through training on Title IX annually. I would really urge you to pay attention to those trainings as you go through them, whether it be an online module or an on-campus module, because things are changing in terms of policy. Universities are continually reflecting upon what they have in place. So make sure that you are staying current through those policies. Additionally, if you have an Office of Institutional Equity and they offer any type of trainings around this topic or a counseling center, I would really urge you to look at ways that you can kind of build those counseling skills to work with students who might find themselves in these types of situations.
Okay, thank you. Any other questions from our viewers? Lisa, anything happening in the Twitter sphere? Are we having any conversations out there? Nope, she says we're not. No questions out there. So you guys did a great job of presenting. Oh, here we go. Okay, can you provide some examples of ways in which advisors tend to break neutrality in these conversations? And I'll just let whoever would like to jump in on that.
Well, I'll take a shot at it. So what I'm guessing is meant by neutrality is allowing yourself to become influenced by the situation. So when we were referencing meeting with a respondent, you have to take into account that they're not presumed guilty until proven innocent. It's the other way around. So occasionally we can have perhaps biases of our own that may influence how we interact with someone, or if we have secondhand knowledge that may have contributed to the interaction, that can also influence our behavior. But it's very important from the perspective of how the advisor interacts with the student to remain as neutral as possible, especially until all of the relevant facts of an incident are known.
Great, thank you. Yeah, it just goes back to what Shannon was saying about just even the language that you use can make a difference in those kinds of things. Any thoughts about ways that advisors can find next level training on this from NACADA or from other places?
I guess I'll take this one. I think in terms of next level training, I think if we're looking at specifically Title IX issues, these are things that we can certainly talk about in the organization and find ways to build this kind of next level training around Title IX into place. And it's something that we can look at.
That sounds great. Any thoughts about how advisors should communicate, or should they communicate, either way, in advance at the start of a conversation that we are responsible employees and we are mandated reporters when meeting with students?
This was a And I'll answer this one. This was something that happened a lot when I was a school counselor. You had to, you always battled with, do I disclose to the student that anything you report to me, I may have to report it if you're harm to yourself or others. That's how it always worked in school counseling. I don't recommend on having a canned phrase at the start of an advising session. I think it's something that usually your intuition as an advisor can see when a conversation is tending to go a certain way. If you're noticing the body language of the student or the tone of the conversation is starting to take a more personal, or you can see that there's something distraught about the student, at that point you may want to read into it and just call them out on that and say, I notice it appears that you're upset, or something along those lines. And within that context, then you can begin to bring up the other campus services that are available. And then that doesn't necessarily put you in the position of having to explain the rules to every student, but rather puts you in a position of being the helper and able to provide the student with assistance.
Okay, great. This one comes from Twitter. I'm not exactly sure I understand, but Shannon, I know you talked about the predictors a little bit, and the question I'm seeing is, what are the positive predictors for predicting who will report? That anything to add from what you've already discussed on that?
I don't think so. I think if you were to look at, I discussed who the offender is may play a factor in their likelihood of reporting. What some of the data shows is that if it's a stranger, they're more apt to report than if it's someone known to them, someone who they're in a relationship with, as they don't want to break that individual's trust by sharing what the incident that's happened. So I think making sure that you are setting up your conversation and your space in such a way that it's felt to be a brave space for the student to be able to share in an appropriate way is probably the space that would make it a more positive way for them to report.
Great, yeah. We've got two questions from two different people, but I think they could very well be intertwined, so I'm going to throw them both out together. The first one is, what is the role of the advisor after reporting an incident? And the other one is, can our advising notes be subpoenaed? So those kind of could go together.
Okay. I think in terms of the role of the advisor after reporting an incident, if the student is aware that you have reported the incident, I think your space is to check back in with the student in the supportive role, just as you would any other situation they might be going through. If they felt comfortable to self-reveal that they've had this incident happen in their lives, that checking in with them as they move through the process as it relates to what's occurring with their classroom environment, is the investigation impacting their ability to complete their courses on time, but keeping it within kind of your role as the advisor and offering supports in those ways and referring out to the appropriate resources on campus. Mark, anything to add on that? Okay. And then in terms of advising notes being subpoenaed, as we noted, you aren't legally protected. You're not, academic advisors do not have their conversations legally protected as, say, an attorney might have or a counselor might have. So your notes as an advisor could be subpoenaed. So keeping that in mind too as you work with students.
Okay, great. Question about, do either of you have any ideas about rates of responsible employees or mandated reporters submitting reports on campuses? Do you know anything about whether those are going up, what that looks like?
I don't have an idea of what the rates are on our campus, since our office is an office of non-report and we actually don't take any reports. So I don't have an idea of what the rates are on this campus, but it is something that most universities are looking at, really trying to educate their faculty and staff about what their role is in the process as well. So yeah, Mark?
I'd have to agree with you, Shannon. I haven't seen an uptick in submitting reports or anything like that.
If a student discloses an incident but has already reported that incident and is working through that process, is there any role for you in that situation regarding further reporting?
I think in that space you're still obligated to report. The student has told you that they've reported, but you don't have verification that they've reported, and so to protect yourself and the institution, even though the student says that it's been reported and they're going through the investigation process, I think the onus is still for the advisor to report in that space. And I think that the supports would be similar as what I had mentioned with the last question.
And I think this is a good opportunity to stress building that relationship with the Title IX office, and that this can be a check-in with them, right, of saying, you know, this was reported to me, the student's alleging that they've already reported it to your office. I just wanted to double check to make sure that the proper channels have been contacted regarding this.
Yeah, I could be wrong about this, but my guess would be that would be that you would give information into them, but they wouldn't give it out to you.
That is correct.
Yeah, that makes sense. So they probably might not even be able to answer whether or not something had been already reported. Okay, viewers, any other questions that we can clear up for you? Okay, looks like we've done a really great job of getting this material and this information out, presented with great clarity, and the technology's worked really well today. So thank you all so very much for being with us, for sharing this information. Viewers, if you happen to think of any other questions after you leave your space today, you're welcome again to follow up with Shannon and or Mark, and they will be glad to answer you by email. So thank you all for being with us today. Take care. Gary?